Good afternoon, and welcome to the Wagner Law Group's series of webinars on COVID-19 preparedness. My name is Regina Mandl, and I'm the head of the Trusts and Estates team at the Wagner Law Group. Joining me today is my colleague at Wagner, Barry Salkin, who is an expert on ERISA law and many other sophisticated tax matters. Today's webinar will focus on estate planning in the age of a pandemic and certain aspects of the CARES Act as they pertain to individuals. You will find a complete list of our other webinars and information regarding our COVID-19 Resource Center on the firm's website, www.wagnerlawgroup.com. Many of you are now working remotely, and the usual interactions with colleagues are no longer available through direct physical communication. While the Wagner Law Group has closed its bricks and mortars offices, we are open for business and are working actively from our homes. I personally find it to be gratifying to be able to be kept busy during this very difficult time. Estate planning in particular is understandably very much in demand. I would like to share with you what we are doing in this regard to meet the needs of our clients. Some of you may be aware that earlier this year, and after the abrupt change in the law due to the Secure Act, which went into effect on January 1st, we sent a letter to our clients regarding the Secure Act. Some of you also may have participated in a webinar that I presented in late March on the Secure Act, or perhaps attended other webinars offered by the Wagner Law Group on that law. It is really now hard to believe that that was our leading concern. While still important, it seems to pale by comparison to what is needed now. As I practice in Massachusetts, I will be referring to Massachusetts law from time to time. However, I do hope that the guidance and observations offered has a broader range. The first thing that I ask clients is if they have lifetime documents. By that I mean healthcare proxy, durable power of attorney, HIPAA release, and living will. I call them lifetime documents as they are the documents that are useful to the clients when living. Next, I ask if they have a present will or a will and trust. If they do, I ask for copies. I ask them to start a list of things to do. I send out an estate planning questionnaire to be reviewed when I meet with clients in a virtual consultation. It is very important to get the information right. Family information. I send clients an estate planning questionnaire and ask for family information, then confirm that it is complete when speaking with the clients. Next, I ask for a list of all assets with approximate values and the name on the title, the owner, and the listed beneficiaries. The lifetime documents usually can be done rather quickly, but wills and trusts are more complex and take time. So consider simpler actions which may achieve many goals to get clients through the crisis. Next slide, please. Ask the clients to locate beneficiary forms for life insurance and retirement plans. These are often available online. If the clients are married, consider recommending that the surviving spouse be named as primary beneficiary. If there are children, name them as secondary beneficiary. And if possible, name a custodian for the minor children. It is important to have copies of what was sent and also acknowledged by the company. They may be needed if later there is a dispute, such as if a company claims not to have the form on file. Then print, scan, and send to appropriate individuals, those people who would need to know the information contained in the beneficiary designation form. Next slide, please. Determine who owns the account. Consider changing titles to pay on death or transfer on death, joint name or separate accounts, or perhaps transfer the title to an existing trust if you have one. Next slide, please. Confirm the names on deeds and if there is a declaration of homestead on the principal residence. Transferring title to a trust may be desirable, but not necessary, and suggests that it be done later if time is not permitting you to do it now. Next slide, please. Now, what would happen if there is no will? Determine if there is no will, then the laws of intestacy will apply. It is important for the client to understand that only property payable to the estate or in the name of the client alone with no beneficiary designation has to go through probate. In some situations, this may be very little property, depending on how the assets are arranged. Simply put, there are assets which will no longer go through probate. These include property held in joint name that will go to the survivor, for example, real estate title in joint name and joint bank accounts. Property where a beneficiary is named, so life insurance, retirement funds with designated beneficiaries on file with the company do not go through probate, and assets with the designation pay on death or transfer on death go as directed and do not go through probate. Here is where it is very important to have accurate information. Once you determine what the assets are, how they are titled, and if there is a beneficiary designated, you can better decide how critical a will really is. While there are many reasons why everyone should have a will, if the client is pressed for time, after determining title and checking the laws of intestacy, you may find that this simple plan is what the client would want anyway, getting property to those who are the objects of his bounty. Now, for a moment, let's take a look at how that might work in Massachusetts. Next slide, please. The laws of intestacy are controlled by state law. Massachusetts has adopted the Uniform Probate Code with some variations, and these laws of intestacy can be found at Mass General Laws, Chapter 190B, Title II. As many of you know, probate statutes and the cases interpreting them can fill books, and no attempt here is being made to cover all aspects of probate laws, which would be a gross oversimplification. However, I do believe there is value in discussing certain laws regarding who generally gets what and who has the right to be in charge. Specifically not included is a discussion regarding how marriage or divorce affects an estate plan. As a starting point for these issues, I refer you in Massachusetts to Mass General Laws, Chapter 190B, Section 2-301 on premarital wills, and Section 2-802 on the effect of divorce, annulment, and decree of separation. I will add that if your client has remarried or recently divorced, you need to determine if they have an existing estate plan and address these issues carefully. So I will only now be highlighting, for purposes of our discussion today, 3 statutes pertaining to the laws of intestacy. Next slide, please. Go back, please. First, if there is a surviving spouse, what does the surviving spouse inherit if there are no descendants and no parents, or if there are descendants who are not his or her own? Take a look, please, at Massachusetts General Laws 190B, Section 102, and 2-103. You'll find under these sections a roadmap as to who gets what under different circumstances. For example, take a look at Section 2-102, the share of a spouse. Well, a decedent's surviving spouse gets the entire estate if there are no children and no parents of the decedent. But it becomes a different story if there are descendants who survive the decedent, or if there are parents of the decedent. For example, the first $200,000 plus 3/4 of any balance of an intestate estate If no descendant of the decedent survives the decedent, but a parent of the decedent survives the descendant, will go to the spouse. And if there are children from a prior marriage or relationship, the law becomes even more complicated. So you need to pay attention if there are blended families and determine who inherits what if there is no will, and also who is in charge if there is no will. The term for that would be the administrator of the estate if there is no will, and a personal representative if there is a will. So when you're looking to see who's going to be in charge, you will find that under section 3-203. And there you'll find that there is a roadmap as to who will be the person who will administer the probate estate. If there is a will, it's the person who's nominated in the will. Then the spouse, if the spouse is a devisee under the will, and any other devisees under the will, meaning the person is named to benefit under the will. If there is no will, the pecking order is surviving spouse, then other heirs of the decedent, then a public administrator. Let's turn to some examples of how this may affect particular clients. Consider this. Bruce and Barbara are married with no children, but have living parents. Barbara has most of the assets in her name. Barbara wants Bruce to inherit everything. If Barbara does not have a will, Bruce will have to share the inheritance with Barbara's parents. Possible solution? Simple wills for each, leaving everything to the surviving spouse, with contingent beneficiaries named. Check all beneficiary forms. Now let's talk about Jim and Jane. They're married and have no children, and they want everything to go to the surviving spouse. They each have living parents. They think that they are okay because everything's in joint name. Jim dies first, and everything goes to Jane by operation of law. When Jane dies, under the laws of intestacy, all her property will go to her then living parents. Here, too, have everything in joint name or payable on death of the surviving spouse, and do a simple will for each leaving everything to surviving spouse, contingent beneficiaries, the parents in equal shares. Mark and Mary are married, and they have 2 children together. The surviving spouse, under Massachusetts laws of intestacy, inherits the entire estate. But what if the decedent had children of a prior marriage? Then the surviving spouse gets less. Take a look at section 2-1023. The short answer, if the clients are married and have children together, the surviving spouse gets the entire probate estate. But if there are parents or children from a prior marriage or relationship, then the surviving spouse will not be entitled to the entire probate estate. Solution, a simple will, and please do check all those beneficiary forms and titles to property. Next slide, please. I divide the document preparation into 2 parts. I first do the lifetime documents, the healthcare proxy, durable power of attorney, HIPAA authorization, and living will, and get them out to the clients as quickly as possible. Only the durable power of attorney needs to be notarized, which does simplify the process. So I limit signatures to what is absolutely required and needs to be notarized if it includes real estate. So even the durable power of attorney technically doesn't need to be notarized, but since it usually is intended to be all-encompassing, it's best practice to have that one document notarized if possible. Next slide, please. See if a simple will can suffice for now. Much can be done with a will and review of the beneficiary forms and changing title on accounts. Remember that the more wills and trusts with complexity should be reserved for later when they can be done more carefully. and only the most compelling circumstances would prompt amending an existing will or trust. Next slide, please. While it is always good to save taxes, young families in particular may consider taxes not to be as important as having access to money and other assets. In order to take full advantage of estate tax laws and provide that the surviving spouse has access to all assets should he or she need it, the client will have to have a trust. Consider making an appointment with a client at some reasonable time in the future to review all aspects of the estate plan, including taxation, when the dust settles. Next slide, please. It is so important in this trying time to prioritize the workload. I personally have a pecking order, I should say, a triage system for who gets to be determined first. If someone is in serious illness or hospitalization for any reason, I put them at the head of the list. Then the clients in high-risk groups by age, pre-existing conditions, and pregnancy. And then, of course, our very noble and excellent first responders in the medical, law enforcement, fire, and military areas. Next slide, please. I send documents that are ready to be executed electronically with instructions for printing and signing. Again, limit the number of signatures to what is absolutely required and be available by telephone to assist. Next slide, please. In this trying time, perhaps the most difficult thing was to find a notary. They are very hard to come by, but many banks will notarize documents for account holders and will also provide witnesses for documents such as wills. It is best to call in advance and make an appointment. And now some states are allowing for virtual notarization. Recently, on April 27, the Commonwealth of Massachusetts did enact a law which allows for virtual notarization. Please refer to the client alert that you will see at, there's a copy of a link to the law itself right here on slide 13. Next slide, please. If you are not going to attempt to do virtual notarization, and if you want to offer to notarize the documents yourself, here's a technique that I call the two-step. Next slide, please. I place a table outside in my driveway. I wipe it down with sanitizer. Gloves and masks used to be preferred, and now I insist on masks at the very least. Everything is signed in duplicate to avoid the need for copying inside. Client signs at the table with her pen, then steps back 6 feet. I then notarize and step back 6 feet. Next slide, please. Client will pick up one set of the signed documents, puts them in a folder, takes them home. I take the other set. To avoid the possible spread of the virus from paper, I personally place them in a safe place for 72 hours. I'm told that may be unnecessary. It may be okay to keep paper for a day or even several hours, but there's no rush. And then everyone should wash their hands or use sanitizer, as we all should be doing all the time. Next slide, please. Be careful about who can notarize for whom. This is determined by state law. In Massachusetts, you'll see a link to Chapter 222. For example, you might be surprised to know that certain people cannot notarize for a sibling or an in-law, even if they're an attorney. There are circumstances when attorneys can notarize for relatives, but they are very, very limited, most of all when it involves a will. I'm not speaking about estate planning and not about other kinds of notary requirements, such as real estate. Next slide, please. Virtual consultations can be done by FaceTime, Skype, or Zoom, taking proper precautions such as password protection. But notarization and witnessing can only be done remotely if permitted by state law. Massachusetts recently enacted on April 27 a virtual notarization law, and the link to that was cited earlier, and a client alert prepared by the Wagner Law Group also appears on this screen. The law is all very new, and some of the requirements may seem arduous. For example, in Massachusetts, copies of the video conferencing and the notary affidavit must be kept for 10 years. In fairness, this is all very new, and we're all trying to do the best we can under these circumstances. Next slide, please. Now, what has to be notarized? Actually, a will in Massachusetts does not have to be notarized to be valid. You just need 2 witnesses over the age of 18. A self-proof affidavit can be added later to the will, and that's at Massachusetts General Laws, Chapter 190B, Section 5-204B. A trust should be notarized whenever it involves real estate, as also the durable power of attorney. Next slide, please. I now happily turn the presentation over to Barry Salkin.
Thank you very much, Regina. I'm going to be discussing 3 issues this afternoon: waiver of required minimum distribution, coronavirus-related distributions, and liberalized rules with respect to charitable contributions. By way of background, historically, the Internal Revenue Code has required distributions from IRAs to commence when an individual attained age 70 and a half. The same rules apply to tax-qualified defined benefit plans, although if you were a plan participant and you continued working after age 70 and a half, unless you were a 5% owner, you could continue to defer commencement of distributions until you retired. Now, this 70 and a half requirement, as you may be aware, was increased by the Secure Act, which increased the date for commencement of distributions beginning after 12/31/2019 until age 72 for individuals who attain that age after December 31st, 2019. But those individuals won't be affected. These distributions referred to as required minimum distributions and frequently referred to by the acronym RMD. The CARES Act waived the requirement for the 2020 calendar year that an individual receive a required minimum distribution. As a practical effect, this will probably only affect a small percentage of taxpayers because it's been estimated that perhaps 80% of taxpayers will continue to draw down their requirement minimum distributions as they need those for current living expenses. And it should also be noted as a side note that there's some indication of an effect in 2020 that required minimum distributions may ultimately be eliminated entirely, but that's down the road. So the RMD relief applies to tax-qualified defined contribution plans, IRAs, 403B plans, and 457B governmental plans. It doesn't apply to any tax-qualified defined benefit plan because those plans simply provide for a fixed dollar distribution. The action taken under the CARE Act is not unprecedented action. It was similar to the 2009 relief after the 2008 financial crisis and meltdown, and this relief was provided under the Worker Retiree and Employee Recovery Act of 2008, and sometimes referred to as the acronym RERA. And it's anticipated, that the IRS will be looking to that as far as issuance of guidance. The waiver rules apply to both distributions that were required for 2020 as well as the 2019 distributions which were required to commence by April 1st, 2020. So absent these rules, if you were a participant who had attained age 70 and a half in the second half of 2019, and you were scheduled to receive two payments in 2020, both of those distributions will be waived in 2020, and your required minimum distributions will be commenced in 2021. It should be noted, however, that the qualified charitable distributions are unaffected by this waiver. Although in the past, typically they have been used in connection with RMD, they will continue notwithstanding the waiver. It is unclear whether this feature is a mandatory feature or an optional plan feature. It appears to be optional, as it was in 2009 under WRERA. But note that even if a plan is not amended and an individual doesn't receive a distribution, there'll be no excise tax for failing to take an RMD in 2020. Now, as a matter of plan administration, you can adopt an RMD waiver currently without taking any action, any formal plan action. A plan amendment would not be required to be adopted until the last day of the plan year, beginning on or after January 1st, 2022, or December 31st, 2022, for a calendar year plan. Now, if an individual received a distribution before the CARES Act was enacted, an individual can still roll over that distribution into an IRA within 60 days. The IRS provided some relief from this requirement in Notice 2020-23, which provided that if your 60-day rollover period would have ended after April 1st, 2020, you can extend that period until July 15th, July 15th, 2020. Note, however, that the 60-day rollover option is not available to a non-spouse inherited IRA. It would be available to a spousal IRA. And you should be aware with respect to individual retirement you're only allowed to have one IRA rollover distribution in a 365-day period. So if you've already taken advantage of that, you may see if you have an opportunity to re-roll the distribution into a qualified plan that accepts rollover distributions. If you were a non-designated beneficiary, for example, an estate or charity, subject to a 5-year distribution rule, if one of those years was 2020, that year is disregarded. So, for example, if an individual had died in 2018, the 5-year period would ordinarily have ended in 2023, but the CARES Act waiver allows you to disregard 2020. So, in effect, the 5-year rule becomes a 6-year rule. And although this isn't noted under the law, one thing that some individuals may be considering is the possibility of converting a traditional IRA to a Roth IRA. And one of the reasons for doing that is that you're likely dealing with depressed assets. So while you'll take a one-time hit if you convert to a Roth IRA, you won't be taxed on the buildup. In fact, one of the reasons that Congress probably waived the required minimum distributions for 2020 is that it didn't want individuals to have locked-in losses. And now I'd like to discuss coronavirus-related distributions. And in order to satisfy this condition, you have to satisfy one of the following conditions. First, you or your spouse or dependent must have been diagnosed with the coronavirus. Second condition is that you've experienced adverse financial consequences because you've been quarantined, furloughed, or laid off, or have work hours reduced because of the coronavirus. A third possible condition is you're unable to work because of a lack of child care due to the coronavirus. Fourth, you may own or operate a business and you've had to close or reduce hours because of the coronavirus. A fifth possibility is that you've experienced an adverse financial consequence due to other factors as determined by the IRS. And to date, not surprisingly, because of the recent enactment of the CARE Act, the IRS has not issued any additional guidance. These coronavirus-related distribution rules apply to a wide variety of plans, tax-qualified DB and DC plans, Code Section 403A annuity plans, Code Section for IRAs, Governmental Section 457 deferred compensation plans. But importantly, as was indicated in the Joint Conference Committee report, a plan is not required to treat a distribution as a coronavirus-related distribution. And there are a number of reasons why a plan sponsor might be reluctant to take that action. First, for the same reason that Congress enacted the waiver, if an individual receives a distribution, the possibility exists that the individual will be locking in losses. And had he or she not taken the distribution, those declines in compounds may subsequently have been recovered. Second, notwithstanding that the law allows individuals with a possibility to repay coronavirus-related distributions, the reality is that most individuals may not be in a position to do so. If you receive a $100,000 distribution and you're currently using that, it may be unlikely that you are unable to return it. And removing $100,000 from your retirement account, particularly if you are far away from your anticipated retirement age, could have a substantial negative effect upon your ultimate retirement distribution. A third possible negative consequence is if an individual is withdrawing these amounts for the purpose of avoiding bankruptcy and then subsequently can't avoid bankruptcy, the individual has lost the benefit of the protection from bankruptcy that that individual would have had he or she retained assets in a tax-qualified retirement plan. So it's by no means clear that all plan sponsors will be adopting this change. If a plan sponsor is interested in adopting this change, one additional step an plan sponsor could take if you have a 401k plan or a tax-qualified profit-sharing plan would be to permit an in-service coronavirus-related distribution prior to an individual's attainment of age 59 and a half. However, if you're a sponsor of a defined benefit plan or a money purchase pension plan, you can't amend your plan to permit an in-service distribution prior to age 59 and a half. However, if you are a sponsor of a defined benefit plan or a money purchase pension plan, you could amend your plan to permit in-service distributions at age 59 and a half, as is now permitted under the Secure Act. The coronavirus, with respect to the taxation, the law permits withdrawal of $100,000 in the aggregate from plans of controlled groups in 2020. And note that an individual who received a distribution of $100,000 from his or her tax qualified plans and $100,000 from an IRA. And it also appears that this coronavirus-related distribution will be available to both spouses. If an individual has multiple IRAs, they can be taken from one or more of those IRAs. And a plan sponsor is permitted to rely upon an individual's representation that he or she is eligible for a coronavirus-related distribution, which differs from the normal requirements for hardship distribution. But note that there's no similar provision in the law for reliance upon participant statements with respect to the control group. So the plan sponsor should require a representation from the plan participant that on a control group basis, the coronavirus-related distributions do not exceed $100,000. Note that while the relief was triggered by the coronavirus pandemic, there was no requirement that the funds that were distributed be used for any purpose related to coronavirus. They can be used for any purpose that the individual requires. These distributions are not subject to the 10% penalty on early withdrawals prior to age 59 and a half, and similarly, they're not subject to mandatory 20% withholding. It is important, however, and you should coordinate with the plan's record keeper, because 10% withholding on these distributions is still required unless waived by the plan participant. So it's important that participants who are requesting coronavirus-related distributions receive notice that they can waive the 10% withholding. And one of the reasons that is significant, that's the Secure Act provides substantial penalties for failure to provide notice to individuals of their withholding requirements. Now, with respect to the taxation of coronavirus-related distributions, they can be included in income ratably over a 3-year period beginning in 2020, and they can be repaid over a 3-year period. That repayment period will begin on the day after the payment is received, and if you receive payment from an IRA, you don't have to return the distribution to the same IRA from which you received the distribution. Any amount that you withdrew can be recontributed in one or more payments within 3 years, and any such recontributed amount won't be taken into account in determining your maximum contribution limit under the plan. So, for example, the 415 limits on tax-qualified DC plans won't be affected. And with respect to the taxation, if you, in fact, included an amount in income in 2020, 2021, and 2022, you still might be able to complete repayment in 2023. In that circumstance, what you would be required to do would be to file amended tax returns for 2020, 2021, and 2022, requesting a tax refund. Now, one alternative to receiving a coronavirus-related distribution would be to consider receipt of a loan. Because that's not an available option under an IRA, because that would be a prohibited transaction. Although, in effect, the effect of the coronavirus-related distributions permitting repayments is in effect allowing you to borrow from your IRA. Again, plans differ with respect to the rules. Even if a plan permits loans, the plan may limit you to one loan, may have other requirements. But the Act also provided that if you were eligible to receive a coronavirus distribution, you are now also be eligible to receive a loan. If you received a loan between March 27th, 2020 and September 20th, 2020, you can now take out a new loan equal to the lesser of $100,000 or 100% of your vested account balance, although both of these limits would be reduced by the amount of any existing plan loans. Now, it should also be noted, however, that the period of time to repay loans has not been extended. So you still have a 5-year repayment period, but you now may, instead of having a maximum $50,000 to repay, have a maximum $100,000 to repay, which may increase the likelihood of default. And another issue that needs to be resolved by the DOL is what type of security, if any, is going to be required if an individual takes out his or her entire vested account balance. When an individual was restricted to 50%, the remaining 50% was the security. And one of the advantages of a loan, as opposed to a coronavirus-related distribution, is that you have a longer period of time to repay, and as long as you're an active employee, your loans will be repaid from your paycheck, kind of a mandatory repayment. Okay, and now I'd like to switch gears and talk about charitable contributions. Prior to the Tax Cut and Jobs Act, well, continuing, generally a deduction for charitable contributions is only available to taxpayers who itemize. But the Tax Cut and Jobs Act substantially reduced the number of taxpayers who will take advantage of the itemization option. And that was the result of two factors. Number one was a substantial increase in the amount of the standard deduction. So, for example, in 2020, your standard deduction is $12,400 for unmarried taxpayers, $18,650 for heads of household, and $24,800 for married taxpayers. And there's also an addition to standard deduction for your age, if you're age 65 or older, and if you are blind, and the amount of that deduction, that increased standard deduction depends upon your status, whether you're married, filing, jointly, head of household, or an unmarried taxpayer. The second reason that fewer individuals are itemizing deductions is that the IRS Congress limited the amount of state tax deductions to $10,000, and particularly if you were in a high state a jurisdiction that had high state income taxes and high property taxes, that amount would be substantially in excess of $10,000. States have attempted to provide workarounds to that, and so far those have been shut down. So as a result of these two congressional actions, fewer individuals are in fact itemizing. And one of the effects on that is that charities have been adversely affected as the number, for example, as the number of individuals who have itemized have decreased was approximately 30% prior to the Tax Cut and Jobs Act. It's now approximately 10%. There was a reduction, example, in charitable contributions in 2018 of 1.7%, and for with respect to contributions under 250, the percentage decline was 4.4%. The change in the rule is that now individuals who do not itemize are allowed to take an above-the-line deduction not to exceed $300. And since this is applicable, however, only for the 2020 taxable year, it's applicable on an individual basis, so taxpayers filing jointly can each contribute $300. There are certain limitations. For example, you can't take into account any amounts that were carried forward from in prior years. If you're going to take advantage of this above-the-line deduction, you're not going to need to file a Schedule A as you would ordinarily do if you were itemizing. This is going to be shown as an adjustment to income on your Schedule 1, and it is subject to certain limitations. It needs to be a cash contribution. You can't contribute clothes, food, or any type of property. Second, it must be made to a 501c3 charity. You can't contribute this to non-operating private foundations, support organizations, or donor-advised funds. The Act itself did not specifically exclude gifts to charitable remainder trusts and charitable gift annuities, but the Joint Committee report, which the IRS generally relies on, indicates that this partial above-the-line deduction will generally not be available with respect to charitable remainder trusts. With respect to documentation, the existing documentation rules will continue to apply. You don't have to attach any documentation with your federal income tax return, but you should keep a written record of all your cash contributions. If the contributions don't exceed $250, a taxpayer can use their bank statement or other documentation that substantiates the contribution was made. If your donation is above $250, you should obtain some document or representation from the nonprofit. A second change that was made was to increase the maximum permissible charitable deduction for individuals. That has historically been based on a percentage of your adjusted gross income. And your adjusted gross income is basically that your gross income was certain above the line deductions. So, for example, under the Tax Cut and Jobs Act, the cap on charitable contributions was 60% of AGI, but for 2020, that amount is increased to 100% of AGI, which would, if you did that, you would effectively eliminate any income tax liability for 2020. It's subject to the same restrictions as the partial above the line $300 deduction. It must be in cash. It can't be made to a non-operating private foundation or donor-advised organization. And if you make a contribution in excess of $100,000, 100% of AGI, you can carry that forward for 5 years. In any subsequent year, the applicable percentage applied to the carry forward will be the Tax Cut and Jobs Act percentage of 60% of AGI. And if you want to take advantage of this 100% of AGI, you have to make an affirmative election on your 2020 income tax return. The service hasn't specified exactly how that will be made. If you are a member, a partner in a partnership, or an owner of an S Corp, each of the partners or each individual shareholder is required to make a separate election. And finally, briefly, with respect to corporate C corporations, the Tax Cut and Jobs Act had limited contributions to 10% of taxable income and 15% for contributions of property. The CARES Act increased both those limits to 25% for the 2020 year, and donations in excess of 25% may be carried forward for 5 years. Regina, I'll turn it back to you for concluding remarks.
Thank you very much, Barry, for your very informative and detailed presentation. I'm sure we all appreciate all the hard work you put into explaining the ins and outs of the CARES Act in this regard. As I've said before, these really are no ordinary times quoting Doris Kearns Goodwin, who was quoting, of course, our wonderful Eleanor Roosevelt. I leave you with this thought. Please stay calm and carry on. For a very entertaining and informative discussion, you'll see a link on the screen to a presentation put together by the Atlantic Monthly Magazine as to the history in England of stay calm and carry on. And those words were as true then as they are today. Thank you very much for joining us, and we appreciate your time. Thank you and goodbye.
Bye.
Hi, Barry.
Okay.